Something massive is happening right now at the United States Supreme Court, and most gun owners have absolutely no idea how close we are to a decision that could rewrite the rules for millions of Americans overnight. We are talking about AR-15s. We are talking about assault weapon bans. We are talking about laws that have been sitting on the books in Illinois, California, Maryland, Connecticut, and several other states. Laws that could be struck down or locked in permanently, depending on what 9 justices decide to do in the coming months. Stay with me, because every single thing I'm about to tell you comes directly from court documents, Bloomberg Law, NPR, and verified legal analysts. No speculation, no filler, just the facts. To understand what's happening right now, you have to understand where we came from. Back in 2008, the Supreme Court decided District of Columbia v. Heller, holding that the Second Amendment protects an individual right to possess firearms for self-defense. Then in 2010, McDonald v. City of Chicago extended that right, making it apply not just to federal laws, but to state and local governments too. But the real game changer came in 2022. The court's decision in New York State Rifle and Pistol Association versus Bruin established a brand new test for Second Amendment cases, a text, history, and tradition framework. Under Bruin, courts must first ask whether the plain text of the Second Amendment covers the challenged conduct, and if so, the government must then prove the restriction aligns with the nation's historical tradition of firearm regulation. That ruling, according to legal analysts at Bloomberg Law, opened the floodgates for challenging gun restrictions that left-leaning states had put in place. And 3 years later, that post-Bruin legal landscape is still coming into focus. Now here is where it gets serious. The case at the very center of all this is called Viramontes versus Cook County. Cook County, Illinois, home to the city of Chicago, prohibits the sale, transfer, or possession of any assault weapon, defined to include semi-automatic rifles like the AR-15. The ban has been in place since 1993 and has been amended twice since then. The law prohibits the possession, acquisition, and transfer of a variety of firearms, including semi-automatic rifles that can accept large-capacity magazines. It specifically names 125 prohibited rifles, including the AR-15. 2 Cook County residents, Cuthberto Viramontes and Christopher Kaya, along with the Firearms Policy Coalition and the Second Amendment Foundation, filed a lawsuit arguing the ban violates the Second Amendment. FPC President Brandon Combs stated that if the Second Amendment doesn't cover the most popular rifles in America, then it covers virtually nothing at all. The case moved through the lower courts. The Seventh Circuit ruled against the challengers. As of February 2026, the petition is still pending before the Supreme Court, having been relisted 9 consecutive times, meaning the justices keep bringing it back to conference without granting or denying review. That is not nothing. That is a signal. Now let's talk about the court itself, because the internal divisions among the justices tell us everything about where this is heading. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch have all indicated they would have taken up prior AR-15 ban cases. Justice Brett Kavanaugh, while not voting to grant review in the Maryland case, wrote a statement expressing doubt that the Fourth Circuit was correct in upholding Maryland's ban. Kavanaugh wrote that the court should and presumably will address the AR-15 issue in the next term or 2. Justice Thomas, writing on a prior denial, stated that the Seventh Circuit's reasoning was unmoored from both text and history, and called on his colleagues to provide more guidance on which weapons the Second Amendment covers. As of March 9, 2026, the court took no action on any of the 4 hardware ban cases, Duncan, Gators, Viramontes, and NAGR, from its March 6 conference. Legal analysts note the justices may be waiting for their decisions in Wolford and Himani, expected by late June, before acting on these petitions. This is a court that is clearly not ignoring these cases. It is a court that is building towards something. While Viramontes sits in legal limbo, 2 other Second Amendment cases are already in play at the Supreme Court right now, and their outcomes will directly shape what happens next. 2 major cases were scheduled for early 2026 arguments. The first involves the prohibition on drug users, including marijuana users, from owning firearms, and the second involves Hawaii's law preventing concealed handgun permit holders from carrying guns on most private property unless they have the owner's consent. The Supreme Court heard oral argument in Wolford versus Lopez on January 20th, 2026. If the court strikes down Hawaii's law, it would effectively impose a national mandate that guns are allowed into private businesses open to the public by default, stripping all 50 states of the power to set their own rules. The second case, United States versus Himani, is equally significant. The Supreme Court heard arguments in March 2026 in a case involving a federal law making it a crime for drug users to possess a firearm, the same law used to prosecute Hunter Biden for illegal gun possession. The case has united strange bedfellows, from conservative gun rights groups to liberal civil liberties organizations. A critic of the law argued that if the court rules against Himani, the statute could apply to anybody, including someone who uses a marijuana sleep gummy. Let's be direct about what is actually on the line here. If Viramontes is accepted and ruled unconstitutional, assault weapon bans in Illinois, California, New York, Maryland, and several other states could be at risk. A denial, on the other hand, leaves those bans in place, and this legal strategy loses significant ground. So far, federal appeals courts have been unanimous in upholding bans on assault-style firearms like the AR-15, likely because the more gun-friendly circuits don't include states that have prohibited such weapons. That unanimity could be challenged in 2026. SAF Executive Director Adam Kraut stated that the Supreme Court has already indicated its interest in settling the assault weapons ban issue, adding that the assault weapons issue has percolated long enough. Here is where things stand as of right now, March 2026. The Supreme Court is sitting on 4 major gun hardware cases. It has heard arguments in 2 live Second Amendment cases. At least 3 sitting justices have publicly signaled they want to take up the AR-15 question. And a 4th justice, Kavanaugh, has put a timeline on it in writing. Legal experts suggest appeals courts may hold off on major gun decisions until the second half of 2026, after the Supreme Court renders its decisions in Wolford and Himani. When those rulings drop, and they will drop by late June, everything changes. The legal map for gun owners in this country could look completely different by July. Watch this space, subscribe, and share this with every gun owner you know, because what happens in that courtroom over the next 90 days will affect every single one of them.